Good afternoon, councillors. Pleased to see you all here. I will start with, before we start the meeting, I would like to inform you that under section 100B 4 of the Local Government Act 1972, I have agreed to the inclusion of 2 items of urgent business being included on the agenda for the meeting today. These are briefings for the committee on the St Neots Public Space Protection Order. That's number 1. Number 2, St Neots Civil Injunction on the Town Centre for Youth and Antisocial Behaviour. Prior to the consultation of these matters in the next month, I am satisfied that this cannot be deferred. These will be considered at agenda items 10 and 11 on the agenda. Thank you. Do we have any apologies?
Apologies from Councillor Criswell and Councillor Jordan.
Thank you. I'll move on to the minutes, pages 5 to 12. To approve and correct record the minutes of the meeting of the Licence and Protection Committee held on the 25th of January 2024. Do we have any points of view on that? Is there anything to be said? No, thank you. Move on to members' interests. To receive from members declarations as to disclosable pecuniary and other registrable and non-registrable interests in relation to any agenda item. See the notes below. Do we have? Thank you. Number 3, Hackney Carriage and Private Hire Licensing Policy, pages 13 to 164. To consider the responses received during the public consultation and approve a new Hackney Carriage and Private Hire Licensing Policy for the District Council.
The Licensing Manager would like to introduce this report, please.
Thank you, Chair. Okay, so my colleague William is going to go through the report in more detail, pulling out the points for you guys to kind of look into further. And then we're going to focus, if that's okay, on Appendix 4, 5 and 6. Because there's quite a few decisions to be made during this report, we thought the easiest way is we'll break it down to the drivers, vehicles and operators, which as said is 4, 5 and 6. So William will take you through the report, then we'll move to Appendix 4. We'll ask everybody if they're happy with Appendix 4 and move on, etc. If everybody's happy with that, I'll hand to William and let him take you through the report. Thank you.
Thank you, William.
Thank you. This report provides the Licensing and Protection Committee with the draft Hackney Carriage and Private Hire Licensing Policy 2024, which is attached as Appendix 1. The draft policy is submitted for approval and addresses new and recent statutory duties placed upon the Council. It also provides an opportunity to revisit a number of existing areas of the policy adopted in 2021, and this is through introducing new or removing existing standards and conditions. All proposed changes are detailed in the policy tracking changes and the appendix tracking changes, and those documents are found as Appendix 2 and Appendix 3. The public consultation took place between the 30th of January 2024 and the 25th of March 2024, and a total of 31 responses have been detailed in the 3 appendices. So Appendices 4, 5 and 6 are broken down between driver conditions, vehicle conditions and private hire operator conditions. These also detail the licensing team's comments to the responses received. If approved by the committee, the final policy, with any amendments made, will be adopted and implemented from the 3rd of June 2024, with certain conditions being implemented at a later specified date. Further details of the implementation can be found in Section 5 of this report. The changes proposed are in keeping with both regulatory codes of conduct, statutory guidance, and the Council's corporate plan. All costs associated with the implementation of this policy will be financed from the receipt of licence fees. The committee is recommended to consider the draft policy documents and the responses received during the public consultation and approve the Hackney Carriage and Private Hire Licensing Policy to take effect from the 3rd of June 2024. The Hackney Carriage and Private Hire Licensing Policy was first introduced in 2018, and part of its implementation was an agreement to review the policy every 3 years. The statutory guidance recommends a review period of every 5 years, and approval of this policy will seek to review the subsequent policies in line with this guidance. A subsequent review of the policy and alterations were approved in 2021, and since then there have been several introductions of new legislation and statutory guidance. There has also been an economic downturn due to the impact of COVID lockdowns and several global conflicts. The review of this policy is necessary to review and implement, where appropriate, changes to reflect the current guidance and changes to legislation. It also allows a review of the economical impact of conditions that may present themselves as a barrier to the licensing team providing a fair and reasonable service for the trade. The draft Hackney Carriage and Private Hire Licensing Policy will have several impacts that benefit the public, the licensed trade, and the licensing team. The changes to the policy will enable a clear, concise, and more consistent policy with several ambiguous conditions amended or removed. If approved, the policy will remove barriers to licensing, increase enforceability of conditions to safeguard the public, and ensure the service remains cost-effective. The risk of not approving and implementing the advised government guidance could see a greater risk to the public, a reduction in providing a cost-effective service, and also legal challenge. It is proposed that the final approved Hackney Carriage and Private Hire Licensing Policy will be implemented from the 3rd of June 2024. The proposed conditions for setting an emissions standard for grant of a renewal vehicle license allows for a graduated implementation, and the full implementation will be determined by the proposal that is approved by the committee. The proposals in the draft policy directly link to the 3 policies priorities listed in the corporate plans: improving quality of life for local people, creating a better Huntingdonshire for future generations, and doing our core work well. The proposals aim to reduce carbon emissions, provide an increase in available wheelchair-accessible vehicles to aid in social mobility, limit unnecessary barriers to trade, provide a more efficient, robust, and cost-effective licensing service, and to promote a safe and secure taxi service. The draft Hackney Carriage and Private Hire Licensing Policy public consultation took place between the 30th of January and the 25th of March. The council website was updated with a dedicated page showing the draft proposals, and direct communication was sent to all licence holders, the County Education Transport Team, Cambridgeshire Constabulary, all neighbouring local authorities, Huntingdon Businesses Against Crime, Environmental Health, Community Resilience, and District Councillors. The consultation was also published in the HDC Town and Parish newsletter on 2 separate occasions. Approval of the draft Hackney Carriage and Private Hire Licensing Policy will create a clear, easily accessible document which sets out the standards for taxi and private hire licensing that will add benefit to both the licensed trade as well as to the licensing team in ensuring public safety. So if you're all ready, I'd like to move us to Appendix 4, which is the driver conditions. So these are the conditions that we have proposed to change and where we've had a response from the licensed trade or members of the public. So,
165.
I don't have page numbers on mine. Sorry, one.
165.
100, no, it's
No, sorry.
Appendix 4, that's agenda item 4, Barry. This
Sorry.
is,
It's so thick.
Yeah.
145.
I think so. Yeah, 145.
Thank you. Sorry, I don't have page numbers on my printout. Okay, so this is relating to driver conditions, and the proposal is this authority needs to be satisfied that a driver's driving ability is competent and of a sufficiently high standard to safely and comfortably convey members of the public. In addition to the mandatory DVLA driving license, it is therefore a requirement that a further appropriate formal driving qualification be undertaken and obtained for all new applicants. And the responses were that we were adding an extra barrier and potentially prohibiting drivers. However, this is not a new condition. It's already in the policy, but it's an agreement that we could be more specific with the final wording, and we can specify exactly what the driving qualification is, which is provided by our external partner, and it is a taxi-specific driving course.
Yes, you can, straight away, councillor, you can, if you've got a response that you want to say, yes.
So I just think that the comment made by the respondent was entirely sensible, I think, and I would agree with rewording it, even though it's not a new clause. I think that's a helpful clarification. Thank you.
Thank you for that. Yes. Councillor Bayward?
Yeah, thanks, Chair. Firstly, it's a good report. Just on this particular issue, it's the definition of an appropriate formal driving qualification. It needs to be clear, I think, isn't it, really? Once we spell that definition out, then, because, my interpretation of what a formal driving qualification is outside your normal driving licence may be different to yours or somebody else's, really. So if we can, drill down into the detail of what that is that an advanced driving course? Is that, what type of qualification needs to be specific, just to manage the public's expectations, really? But in response, I think, the response is fine, and if we can cover that off, then I'm happy.
Thank you. Would you like to respond, Robin?
Yeah, just in agreement that we can definitely word that. So instead of saying further appropriate formal driving qualification, it will specifically state what the requirement is. And I think we have a range of 3 providers that drivers are able to access, and we can make sure that that's abundantly clear in the final condition.
Thank you. Is there any other council wish to?
I think if I can just add to that, I think we'll also make that very clear on the website. So where these changes are coming in, we'll make that clear. So a new driver will be able to look on the website and see which courses are available and suggestions for them. So yeah, absolutely. So before we, if that's okay, Chair, before we move to Appendix 5, is everybody happy with Appendix 4? There was only obviously one on there. Yeah.
We'll have to approve that.
Yeah. Can I put the
No,
recommendation?
not that recommendation, we're just doing the appendix.
Oh, the appendix, sorry. Yes, councillor Clark?
Yes, I haven't got a light. Yes. I note the emission standard, there's going to be an emission standard. Isn't there a danger that you'll set up people to fail? I mean, I suspect we're hoping to go with electric things, but if it don't avail, aren't we setting up people to fail with an emission standard?
Thank you for that. Very interesting. Councillor Clark, will you respond, Michelle?
Councillor Clark, is it okay if we come to that bit when we come to the vehicles? Is that okay? If we can just do the driver bit first, then we'll come to the vehicles, because my colleague can explain then why we've decided to look at the emissions, if that's okay. Thank you.
Thank you.
Okay, thank you. So Appendix 5, as you can see, is quite a lengthy document. And if you're all in agreement, what I propose to do is to read the condition, and then if you have any comments based on what's written, rather than me reading every page and every word, I'm sure you could do without that. So we move to Appendix 5, which is the vehicle conditions. And we start with Appendix B, conditions 7.1 to 7.4, which state that private hire vehicles must also display, securely affixed on the outside to the rear of the vehicle, the yellow license plate as issued by the licensing authority. An internal license plate as issued by the licensing authority must be displayed on the front windscreen. Private hire vehicles must have signage on the rear passenger doors of the vehicle as issued by Huntingdonshire District Council. And at all times, private hire vehicles must also display signage bearing the name of the private hire operator for whom the booking is being fulfilled. This signage may be in the form of a logo or text and must be displayed on the front doors of the vehicle in a clear and legible way. So the responses that we had to this specifically were in regards to the safety of taxi drivers or private hire vehicles when they're not using the vehicle for license purposes. And the proposal put to us was that the signage could be removed when not in use. And it's our position that as long as we specifically state in the conditions that whilst in use, all of this signage must be removed, we don't see any harm in that signage being removed when the vehicle, say, parked upon the road, or the taxi driver is using his vehicle to go for a family trip to the seaside.
Yeah, thank you. I'm just thinking from a practicalities point of view. So if we give the ability to take these signs off a taxi when it's not in use, are we creating a loophole in relation to, I'm just thinking of a scenario where a police officer's following a taxi with passengers in and loses sight of it and goes onto an estate and then finds said vehicle and plates have been removed. Will that create an issue that, because then the driver can say, well, actually, they were in my vehicle, but I wasn't operating at the time. So I'm just thinking about potential loopholes that could be created by taking plates on and off, really. So I'd be interested to hear your views.
Yeah, thank you. And it is an interesting point. There's always going to be some degree of a loophole with signage. If a driver isn't displaying them currently right now, we don't know until that vehicle is seen without the signage. There's always going to be an element that the responsibility is placed onto the driver. I think the intention of what the response here was is there is a lot of thought within the licensed trade that the taxis are specifically targeted for break-ins, or they're specifically targeted for criminal damage because of the overt nature of the vehicle. And what the condition is asking for is whilst in use, but allowing some flexibility that when the vehicle's not in use. So in the scenario where the vehicle is being pursued by the police, or needs to be visible, if it doesn't have the displayed signage on, it is in breach of its conditions. There are sanctions we can take. Likely that if the police were to stop the vehicle, there would be some form of PDA device. It's very rare for a taxi company to not utilize a PDA device for the booking. So there's other ways of being able to tell. And obviously the police could interrogate the passengers through simple questioning as, is this a taxi? And I don't think the passengers would be in a position to lie for the driver necessarily. So I think there are some natural safeguards in place, and this just removes any concerns that the trade may have of damage or targeting of the vehicle.
Thank you. Yes, Councillor.
So this whole appendix, I think, is full of really thoughtful responses. It's been an excellent consultation. I also think you've done a good job in responding to the responses. So I think this clause is perfectly sensible, and it's important that people are safe when they're driving their vehicles and they're not taxi drivers. And I don't think it's a big concession for us. So I would support the changing of the words.
Cool.
Thank you, everyone. Moving on to Appendix B, which is calling for the removal of door signs for Hackney carriages. Now, we had no significant responses to this. However, it is a big departure from policy, so we felt it relevant to highlight at today's meeting. A Hackney carriage, by definition and by requirement, has to have signage displayed on top of the vehicle indicating that it is a taxi. It has to have signage indicating that it is for hire, and it will also have to have internal and external plates, as do all licensed vehicles. Our proposal is to remove a burden on the taxi trade, and also a departmental burden is removal of the additional signs that say licensed Hackney carriage vehicle, as we feel that there's already sufficient signage in place for those vehicles. And any questions, please ask. Yep, so I can confirm that we're happy with that condition.
Thank you, William. Yeah.
Okay, so section 26.5 to 26.8, which is also mirrored in Appendix B 1.9. So just to clarify, the main policy is broken down in sections, and then supporting the policy are individual appendices. So you may see some duplication here. These conditions are calling for the removal of existing grandfather rights. All Hackney carriages licensed between Hackney Carriage 1 to Hackney Carriage 44 have retained grandfather rights, enabling them to be saloon-type vehicles. Now, under the Equalities Act, Hackney carriage vehicles are required to be wheelchair accessible by design. there's no restriction in place for private hire. So the only way that you can designate a wheelchair accessible vehicle by demand is through Hackney Carriage licensing. At present, the Hackney Carriage licenses between 1 to 44 have had grandfather rights since the Equalities Act came in 2010. And as long as there has been a licensing policy in this district, the grandfather rights have continued on and on each year with no closure or progression towards a wider range of wheelchair accessible vehicles. The proposals would see that once a vehicle is removed from licensable trade, whether that's the decision of the license holder or whether that's because the vehicle no longer meets the requirements such as emission standards, such as age, or the vehicle is just not safe to be on the road, this plate would therefore no longer be able to transfer to another saloon. It would have to be relicensed as a wheelchair accessible vehicle. So the proposals aim to close the grandfather rights, and this would be on a renewal basis or on the basis of when that vehicle comes out of trade. It wouldn't be immediately all vehicles cease. We received several responses from this regarding the actual cost of a replacement vehicle. We've received several comments and thoughts about it with regards to how it would be financially impossible for the trade to do so. However, we feel that with the other proposals that we're putting forward in this policy, that a wheelchair accessible vehicle is within the realms of affordability, and it is a very much a tiered and staggered approach to achieving that. Thank you, Chair.
Thank you very much for that. Which was we going to? Oh, Councillor Stevenson Ferguson.
So with regard to this one, I've had several comments from members of the wheelchair using community about the lack of availability of taxis of both kinds, private hire and Hackney carriages. The Equalities Act's been in place since 2010 and placed a basic requirement that all Hackney carriages should be wheelchair accessible, and these grandfather rights seem to be just a loophole which prevents that happening, which I think is very sad for the people in the community who have to use wheelchairs and therefore cannot use taxis because there's not enough vehicles. I can understand the commercial constraints on those drivers, but 2010 to 2014 is a long time, and I think these must be quite old vehicles. I also understand that there's quite a secondary market in those plates. So if you were trying to pass those plates on, they go for quite much more expensive rate than a normal plate. Now, I don't really understand. I don't have a good understanding of how license plates are sold and passed on, but I think that demonstrates that those drivers are also operating under a significant commercial advantage to the drivers who have to have newer vehicles, and that would strike me as being unfair as well. So I think I would support the recommendations.
Thank you. Is there any other questions, William?
Are you all happy with that one?
Are we all happy? We can move forward.
Thank you, Chair.
Thank you.
So moving on to Section 3, 16.1 and 16.2, this would state that any application for the grant of a new Hackney carriage or private hire vehicle licence, including hybrid or fully electric vehicles, must as a minimum meet Euro 6 emission standards. And from the 1st of September 2024, any existing licensed Hackney carriage or private hire vehicle must as a minimum meet Euro 5 emission standards. This new standard will be applicable upon renewal of the vehicle license, and if it does not meet Euro 5 standards, the license will be refused. This one we had significant response to, possibly the single most responded point to. A lot of the trade was actually in support of the Euro 6 emission standards. The reason for that is it stops the current 5-year age restriction, which isn't a dynamic restriction. 5 years is a 5-year-old vehicle today, but it's not a 5-year-old vehicle in a few years' time because that goalpost keeps shifting. The Euro 6 is the current minimum standards for new production vehicles. As that changes into Euro 7, Euro 8, or any variations, it's much more of a fluid progression towards achieving the emission standards, and it does remove what I feel is an unnecessary barrier to licensing a vehicle that simply 2011 is too old to be licensed, but has potentially the same Euro emission standard as a 2019 vehicle. So this allows it to be based off of the Euro capability rather than just simply an age, which is very static. So there has been a lot of support in removing the 5-year and going to the Euro 6, but there's also been a lot of countering in that shifting from a Euro 4 vehicle to a Euro 6 is going to be very expensive, very difficult. And we have looked into the numbers. We're looking at a sort of 15% of the trade have a Euro 4 vehicle. And we are aware second-hand car prices, the availability, there is a financial implication. And obviously the original proposals of September are a very short window between June to September to get these vehicles replaced. So what we've proposed in response to what we've heard and the feedback we've received are 2 proposals. The first would apply to all Hackney Carriage and private hire vehicles that are not wheelchair accessible, and any license holder who has a Euro 4 emission standard vehicle from the 1st of January 2025, giving them 6 months, would be in a position to renew the vehicle with a Euro 5 vehicle instead of having to go in at the new Euro 6 category. And we've proposed a second option for the wheelchair accessible vehicles, which would be from the 1st of June, giving them an extra 6 months as they're harder vehicles to come by. And that would also allow them the opportunity to replace their Euro 4 vehicle with a Euro 5. So again, it gives for the existing trade and the existing license holders, it gives them a slightly more graduated approach rather than just sort of dumping them straight from 4 to 6. So thank you, Chair. I invite any comments.
Thank you. Is there any comments from councillors?
I have a question. Why are we still referring to Euro? We're not actually in Euro.
Yeah, so post-Brexit, there's been no implementation of a UK-specific emission standards. It is still, Euro 6 are still the standard production requirement.
Thank you. Yes, councillor Clark.
Thank you, Chair. I'm still concerned that you are possibly setting standards that could not be met through not the driver's fault. I'm hearing now that electric cars are being returned to garages because they're not working. And I can see, I'm in the farming and haulage, and it's being talked of now that it can't possibly work. So I'm concerned that you're setting standards that can't be adhered to through no fault of the taxi driver. It'll be the situation the country's in, and I think there should be something put in to cover that if that happens.
Thank you. Would you like to respond, William?
Sorry, yeah.
Yeah, thank you. It is a very valid concern. It's one that we hear echoed in feedback from the trade. Now, some neighbouring authorities within this county have shifted to a full ULEV, ultra low emission vehicle requirement, or a electric hybrid. We don't feel as a licensing authority that there is the infrastructure in our district. We're very rural. There's not the availability of charge points like there might be in a more urban area. Which is why we've gone for the Euro standards, which apply to petrol and diesel vehicles. There's no specific requirement to shift yet onto electric vehicles. And just to give some clarity, Euro 5 vehicle was first mandated for all new production vehicles in January 2011. So at the minute, we're saying all renewal vehicles can be up to 13 years old. Based on sort of production, and that all new vehicles must be Euro 6, and that became mandatory in 2016. So we think we're actually widening the scope of available vehicles to the trade. We're not forcing them to go down to the electric hybrid route, but we are giving them a graduated step towards cleaner emissions. And the vehicles will still be held to the same safety standards, and they'll still be held to the same emission standards through your ordinary MOTs. So if that vehicle has a Euro 6 standard, but cannot meet the emissions test on MOT, it simply wouldn't pass. So that wouldn't be like a haphazard, barrier that could hinder the driver. That would be down to the driver's decision not to present a vehicle that's capable of passing. We don't feel that at the minute these restrictions are doing anything other than opening up the playing field to give drivers a better standard, but also moving towards the greener emissions. And then upon next sort of policy review, it may then be that government infrastructure or local infrastructure is shifted, and it would allow us to then progress even further.
Thank you. Yes, Councillor Ferguson.
So I support Councillor Clark's comments because I don't think that the current standard of electric vehicles is suitable for rural taxi drivers. I speak to a lot of taxi drivers and I ask them about, and we often end up talking about electric cars, and I don't think that the range is there yet for our area, although it's something we might want to consider in the future. We also don't live in a city environment. We just recently removed some of the air quality constraints on St Neots, recognising that it is kind of that emissions are improving, and they're improving because we've taken action like this, and car manufacturers are delivering cleaner cars. And so I think that, as you said, that the fact that a Euro 5 car can be up to 13 years old, there has to be a limit on the age of taxi vehicles, and I think that that's a sensible measure. And I think your phased response for wheelchair and non-wheelchair compliant vehicles is entirely sensible and gives the trade a chance to catch up. So I can understand that it's another financial stress on taxi drivers, but I think it's a realistic one, and I think we can't really expect very old cars to still be used as a taxi driver. If I was a customer, I would be disappointed to be in a 13-year-old car, I think, when I'm paying for its use. So I think these are sensible requirements. But I acknowledge completely what you're saying, Councillor Clark. I think it's too early to move towards electric vehicles or taxis, would be my view.
Thank you.
I think it's just worth noting as well, and as William said, our current standard is that for all new vehicles that come on to be licensed, they have to be a maximum of 5 years old. Whereas moving to this, obviously, that's, as we said, that's opening up the wider scope of vehicles, and that's been a conversation that a number of members have spoke to us about and said, actually, it's quite hard on the trade. So we've listened to that and looked at the options.
Thank you, Michelle. Is there any other questions? Thank you.
Are you all happy with that point? Yep.
I think just to clarify, I think that's proposal 1 and proposal 2. We just need to, if everybody's happy with proposal 1 and 2.
Yep.
Yeah. Okay, thank you.
Okay, moving on to section 3, 16.3, and this would see any licensed hackney carriage or private hire vehicle that is still licensed once it reaches 8 years old or more from first registration. So this isn't from first date of license, this is from the date of first DVLA registration. And the vehicle would have to complete a certificate of compliance check at the council approved garage every 6 months for as long as it remains a licensed vehicle. Similar to the previous proposals, we had a lot of response that it was an unnecessary and arduous cost put onto the trade, as they would have to pay for 2 compliance tests per year instead of 1. A lot of them felt that it was unjustly targeting older vehicles and blanketing across, saying that the vehicles weren't safe to be on the road just because of the age. And a lot of the proposals were saying we should do more work to find different alternatives of how to regulate the older vehicles. Now, what we've done in response to that is we have benchmark across every other district. Cambridge City have a requirement that all vehicles are to be tested every 6 months. That's regardless of age. Peterborough City have a slightly hybrid approach in that for any vehicle that is a hybrid vehicle with emissions of 105 grams per kilometre or lower, or if it's 6 years, if it's conventional fuel. So they have a 6-year target and an 8-year target where vehicles have to go every 6 months. Fenland District Council, all vehicles after 5 years of age are tested every 6 months. South Cambs District don't provide a frequency from what we were able to determine, but they do require both a standard MOT and a certificate of compliance. So they're requiring essentially 2 tests, but done at the same time. And East Cambs District, all vehicles after 6 years of age must be tested every 6 months. So it's felt that our proposals, again, potentially are I don't want to use the word lenient because that's not the intention of it, but they are the probably the most lenient of all the districts. But that's taking into account that we are shifting our Euro vehicles, we're shifting towards potentially a better fleet. So let's give that a graduated step. And again, with the policy reviews, we could look to reduce that to every 5 years, 6 years. We could take an approach such as Cambridge City, but it's felt that at the moment, the 8 years is a sufficient time to do that. We've noticed a significant number of vehicles that are failing compliance checks that are getting reported to us by the DVLA, the DVSA, Education Transport, have school monitoring officers, and these vehicles aren't fit to be on the road, and a lot of them are older vehicles, and it's just not possible as a licensing department from a cost perspective to regulate vehicles in any other way for testing other than an age policy. So whilst we don't feel that that's appropriate to licensing them for the first time, we do feel that it is the best approach for the actual inspections, and that would be our proposals. So any questions? Thank you, Chair.
Thank you. Yes, Councillor Hurl.
Yeah, I just want to say I support that because there are certain instances where cross-border offices appear that have nobody in them just to get licensed in the district. I know there's a couple of them in Yaxley, so having that would level the playing field a bit.
Thank you. Yes, Councillor Ferguson.
So this is a difficult question, isn't it? Because any limit's going to be arbitrary. And if you look across the wide variation of conditions imposed by neighbouring authorities, it goes to show just how absurd licensing is at the moment, in that every single district or city council has a different requirement, and none of them marry up at all. So I think you've taken a sensible approach. I think that being tested 2 times a year is an arduous constraint on taxi drivers, but I think the requirement for over 8 years old is a sensible one, especially when you consider the quantum of other restrictions in local councils, and that many of these companies operate across borders anyway. So I think it's a sensible compromise, but an arbitrary one, and you could argue either way, I suppose, but I think it's a good suggestion.
Thank you, Councillor Ferguson. Is there anybody else like to speak? Yes, Councillor Bywater.
Yeah, I'm in agreement. I think we've got a duty to public safety at the end of the day as well, haven't we? And if I was getting into a cab, or a family member of mine was getting into a cab and it hadn't been checked for over a year or 12 months, then I wouldn't particularly feel very safe, really. So I think it is a shame that it's going to add an additional cost for commercial companies, but I think this is a sensible approach. So happy to support it.
Thank you.
Okay, thank you, Chair. So moving on to section 324.9, and this will be the last one for Appendix 5. A hackney carriage driver or private hire operator must ensure that the customer is offered the option of making payment via card or cash. We did receive support in this condition. However, an operator did come back to us and asked for some clarification that cash payment was not what was required through this condition, but rather the facility to provide card payment. So this is an operator that exclusively operates on a pre-booked card via app only, and they were concerned that the nature of the wording would require them to then start offering cash payments, which they want to avoid. They don't want any transactions between the driver or the passenger. So it's just to get your approval for clarifying that the final wording will be that the card payment option must be offered, but it's not a requirement for cash. And the logic behind that is really to everyone pays by card these days, and it's to enable passengers that facility rather than being driven to a cash machine in the middle of nowhere at night. Thank you, Chair.
Thank you. Any questions? Yes, Councillor Ferguson.
Can I ask for some clarification on that? So I understand the response from that operator, who is a strictly online business of the type of Uber or Bolt, and so you don't book those things by cash. That's fair. But your standard private hire vehicle or hackney carriage, are they required to take cash still, or do you have to use a card? Can you just clarify that?
Yeah, thank you. So it's basically a choice. An operator, there's nothing in legislation that can restrict us from taking cash payment or enforcing a restriction of cash payment because it's legally accepted tender. So what we're doing is, by this condition, we're not saying drivers must take card payment, but they must be able to offer the choice to passengers, because a lot of passengers will still pay via cash. It's just trying to shift drivers away from only demanding cash and actually offering an option, specifically Hackney Carriage drivers that aren't pre-booked.
Then I think that's completely sensible. One of the reasons I didn't used to use taxis in the past, because I used to hate sitting at the back with a wad of cash and seeing the meter go up and thinking I'm not going to be able to afford to pay for this. So the provision to use cards for me, I understand lots of people still use cash, and I think it's important that we still keep that alive as much as possible. I think the vast majority of people would prefer to pay on card these days, so I think that's very sensible.
Thank you. Councillor.
Yeah, I just have a comment/question as well. Okay. I completely think this is a really, really good condition. Having experienced this myself, where being driven into the middle of nowhere, trying to get cash from a cash point, and then the taxi driver charging more, and it's so I think this is really great. However, in terms of using card, does this affect the rates that the taxi driver will be charging because of the amount? If they're using a card machine, or is it a card machine, or is it bank transfer? Because in recent times from Huntingdon Station, I have been given the option, but I've had to go on my app to do a bank transfer, which took a long time to do. If they had a card machine, that then would have impact their profits and everything. So what is the facility around that? Thanks.
Yeah, so I'll make some initial comments, and then Michelle will also come in on that. So it's going to be driver or operator decision whether they have a sort of contract with your WorldPays, your standard, or whether they'll go through the Bluetooth connecting up to your phone style card payments. With a Hackney Carriage, the rate cannot be anything higher than what is shown on the meter. So they couldn't charge 50p, £1, £2 for that card transaction. We're aware that there are processing fees, but obviously there's national law that prohibits a transaction fee being placed on now. I think that was January 2021, perhaps that came in. So the drivers are going to be restricted by not doing that through legislation as well as the Hackney fares. And then with regards to bank transfers, I'll let Michelle answer that one. Thank you.
Thanks, William. I think to be honest, again, we can look at the condition and make it very specific in terms of a card payment within the vehicle, rather than being a bank transfer, because I think you're absolutely right. That's a long way around of doing it. I think the majority of these have got apps nowadays where you can actually make the booking on the app and you pay for it there and then. And the majority of other people, as William said, have got their phone that literally it's like they put the amount in and you tap your card on and the payment's made. So, in terms of bank transfers, I think that will be few and far between, but certainly we can amend that wording so it clearly states not as a bank transfer. It needs to be a readily available method of payment via a card machine, phone or machine within the vehicle. So yeah, absolutely. We need to look at that from, you're absolutely right, from the safety element, and this is one of the reasons why we've brought in this condition. We have had a number of complaints in the past where, persons of late night have been driven to a cash machine because they've got no cash on them, and that's not safe. So it's something that we wanted to do. As William said, we can't necessarily say that no cash payments, we're not going completely cashless. That's obviously the driver and operator's choice. Some operators do operate as a cashless system. You can only pay for it on the app at the time of booking. So, we would encourage that, but we can't say completely no cash. But we're going to push, obviously, that they need to have this card payment. Okay.
Thank you, Michelle. No more questions?
Could I just clarify before William comes in? So Appendix 5 is all finished. Is everybody happy with all those? And we'll move to Appendix 6. Yeah. Okay.
Right, thank you. So you'll be pleased to know Appendix 6 is much smaller than Appendix 5. I'm going to ask you to go just slightly to and fro on this one. I do apologize, but upon further reading, I've realized two of the conditions and the responses are very, very similar and overlap, so I think it would save a bit of time. So at the start of Appendix 6, you have Appendix D, sections 1.1, 1.2, 5.3, and 5.4. And then on the very last page of Appendix 6, you have section 3, 26.12. Now, these conditions are all centered around operators ensuring that drivers are appropriately trained, and it's also about dispatching wheelchair accessible vehicles and ensuring that the driver is suitably trained to do so. We received several responses in relation to these, and the responses generally were putting the responsibility back onto the local authority to ensure that the drivers are suitably trained. Now, as part of the initial application phase, they are required to undergo a taxi driver assessment, which does cover customer service, sort of handling and safe handling of passengers, not to the extent of wheelchair accessible, but just helping people in and out of the vehicle. Driving specific assessments are also conducted, but it doesn't go so far as to train a driver on company policies, company complaints handling procedures, and all of the things that as a responsible operator we would expect to see them demonstrating to their drivers. And specifically with wheelchair accessible vehicles, there is no requirement for a private hire vehicle to be wheelchair accessible. So anyone who licenses one is doing so voluntarily. It is their decision to license that vehicle for that purpose. And often it is the operator who is licensing the vehicle, not an individual driver who owns the vehicle. So basically, we do believe that in Appendix D, making sure that drivers are suitably trained in disability equality, company policies, we're not prescribing exactly what they need to be trained in, just that the operator needs to make that decision. And when we come to do our checks, they can proactively demonstrate that they are training their drivers to be suitable for the role that they're being asked to conduct. And with specific requirements of wheelchair accessible vehicles, having received some feedback from the environmental health team, let me just check that it is definitely... Yeah, so that would be in relation to 26.12 on the last page of Appendix C. And we believe that we can reword this condition to ensure that operators must ensure that the drivers have been appropriately trained in the use of wheelchair accessible vehicles and relevant belts and other restraints, rather than having the wording read that the operator has to be the one that provides that training. So we do take on board that whilst the operator isn't necessarily obliged to provide the training, they need to be the ones that ensure that they are trained to use those vehicles. So I hope that's clarified it, but please, any questions, I'll be happy to come back in.
Councillor Ferguson.
So this marries up with a comment I got from a wheelchair user who says that she no longer uses taxis because even if they're wheelchair accessible, she's not confident that drivers know how to safely secure the wheelchair or use the seatbelt, which is obviously a non-trivial technical task. And I think that the risk of a driver turning up in a wheelchair compliant vehicle, because they don't always drive all the same cars all the time, I don't think, and not being able to secure a wheelchair are incredibly high. And so that level of training is really important. This is an important consideration, and hopefully will increase the confidence of the wheelchair using community in using our taxis. So I think this is a very important condition.
Thank you, Councillor.
Yeah, thank you. And part of the options available to the committee to actually make a decision on, with specific reference to 26.12, as I stated, a wheelchair accessible vehicle in terms of private hire licensing is a choice by the driver or the operator. A Hackney carriage vehicle it's not a choice unless it's one of these grandfather rights. So there needs to be an element of training, but then it's down to the individual driver to demonstrate that. One of the options you could impose by way of condition is you could adopt a requirement that all license holders and new applicants have to undergo the additional wheelchair accessible training upon all licenses. Now, the downsides to that it would put a burden on all drivers to pay, I think it's something like £65 extra for the wheelchair accessible training. And certain drivers may never step foot throughout the entirety of their career in a wheelchair accessible vehicle. So it's a bit of a blanket approach to put that burden onto the drivers to have that training. Or the option is you approve the slightly amended wording of 26.12, whereby it's the operator's responsibility to demonstrate that the driver has been trained, whether they fund that training or whether they require their driver to fund that training. At least then it's covered and it's specific to the drivers that will be using those vehicles.
Thank you. Yes, Councillor Bywater.
Yeah, just trying to think of this. Are we making it maybe potentially too cumbersome that, you know, we put drivers off from being good drivers that can convey wheelchair users? My concern is if we make it too cumbersome, then we'll potentially create a shortage of wheelchair drivers, really. So I'm sort of erring on the side of, you know, the operators can prove that to us, really. That would be my view, really.
Thank you. Yes.
I agree with Councillor Bywater as well. I'd err in favour of the second option.
Thank you. Anybody else would like to speak on that? Is that okay, William? Thank you.
We're all agreed on the second option. Yeah.
Fine.
Thanks, Chair. Okay, so moving to Appendix D 1.3, operators must be aware of their obligations under the Immigration Act and only utilise persons who have the right to work in the UK. Failure to observe this requirement or to provide due diligence checks may be subject to enforcement action by relevant Home Office department. We've received a response from one of the operators stating that due to the self-employed nature of drivers, a lot of Bolt legal cases and Uber legal cases in London, where it moved away from this 0 hours contract and the gig economy, has brought up the recommendation that they would like us to change the term utilize to employ. Now, it's my feeling that the wording should be changed to and only provide bookings to persons who complete bookings, because the word employ used by an operator could be a loophole to say, well, I don't employ this driver. They're self-employed. I'm passing them the jobs. I have no responsibility if they've got immigration status or not. I think we open ourselves to being too ambiguous. So I think if we just provide a more simplistic approach. Thank you, Chair.
Thank you. Seeing it, okay.
Look, I'm not skilled enough and knowledgeable enough in relation to the legal definitions of this, really. Have you taken legal advice on that so that we don't create a loophole? You know, I'm looking at you as officers to give us the steer in relation to this, because I'm not qualified enough to say what the wording should be, really.
Thank you.
Yes, thank you. That's very valid point. And I know we're certainly not qualified to necessarily make the legal definitions. To date, we've not sought legal advice on that, as it's felt that by changing it to only provide bookings to persons to, you're completely removing the specificity of employ, not employ. It's any person that, as an operator, you are giving your booking to. So it covers self-employed or employed, and it puts that obligation onto them.
Thank you.
Thank you, Chair. So Section 3, 15.4, which is also covered in Appendix B, 7.4, and Appendix D, Section 2.4. This is a condition that states the operator's name and contact information must be displayed on the vehicle unless a valid private hire plate exemption has been issued. Now, this condition is an area of contention for operators. We've got a very large operator in support of this condition, and we've got one very large operator who is challenging the rationale behind making it mandatory. The Department for Transport issued new guidance on door signs. Under their sort of questionnaire and feedback and their sort of insight into it, it was felt that by having a operator name displayed on the vehicle, it could create confusion between a private hire vehicle and a Hackney carriage vehicle, and it would confuse members of the public into thinking that these vehicles were immediately hailed on the spot. The same DFT guidance and feedback then goes to state that a pre-booked only sign displayed on a vehicle helps differentiate between a Hackney carriage and a private hire vehicle. Now, it's our thoughts that this is actually quite contradictory, because the DFT are saying, on one hand, a sign with a company name will mislead the public, but a council-issued sign stating pre-booked only will not mislead the public and will help differentiate. It's our thoughts that by having the name of the company on the vehicle, it's one additional safeguard for members of the public to be able to easily identify that it is their vehicle, that it is a licensed taxi. It helps other road users, other sort of services such as road traffic police identify these vehicles as such. But it also, it's sort of a condition that could go either way, because part of the feedback against it is it does create the ability for a vehicle to be parked upon the side of the road as a private hire vehicle, and it's immediately obvious that it is available for hire, even though it has to go through an operator, and it may encourage people, members of the public, to approach this vehicle and try to use it without a pre-booked journey. And one of the operators felt that it also acted as a target for those vehicles, and people were putting malicious complaints in or targeting these vehicles. So it's one that from the licensing team we see both benefit and we also see benefit against. And it really does come down to what we feel is most appropriate within the district. As the DFD guidance, we have to give consideration to it, but we can deviate away from that if we feel that it is just in doing so. Thank you, Chair.
Thank you, William. Is there any comments on that? Yes, Councillor Ferguson.
I just agree that the DFT guidance is contradictory in some ways, and so I think your analysis is correct.
Thank you.
So just to clarify, are we in agreement that we believe for this district it is necessary to display the operator's name and contact information on all private hire vehicles?
Yep. Thank you for that, William.
Thank you, Chair. Moving on to Appendix D 4.6. This condition states that where a premises is open to the public during the nighttime economy hours, and on this condition it has been noted that the time should read 2300 hours to 0500 hours. There has been a typo in there, apologies. The private hire must conduct an ongoing risk assessment to ensure that where it is considered necessary, sufficient SIA security officer doorman will be employed at the premise. Now, the response to this is that it's an unnecessary cost and burden placed onto the private hire operator. Now, the intention behind this condition was much like a licensed premise, whereby we know they're going to be operating into late night economy, there's going to be potential for lots of people gathered, is we're not mandating you have to have SIA door staff, but that you need to conduct a sufficient risk assessment. And risk assessments don't have to be 15 pages long. They can be a simple document to say, we've assessed the need, we do not believe we need it. Examples are, there are a few booking offices in both St Ives and St Neots, which are open to the public. Obviously, the district at the moment doesn't have the greatest late night economy, but with the regeneration schemes going, there is potential for more and more late night applications to come in. And the thought process behind this is, if you've got something such as the St Ives Festival, St Neots Festival, where there's going to be large groups of people potentially under the influence of alcohol, 2 o'clock in the morning, they're all waiting inside of a taxi office. There is potential for public disruption, fights to break out, and it's putting an onus onto the operator to make sure that their premises don't then become a beacon of ASB or violent crime. Thank you, Chair.
Thank you. Yes,
Just going to say that
Ferguson.
I'm very familiar with some of the shenanigans that goes on at St Neots taxi office after the pubs kick out. I mean, there isn't a very late night economy, but it is often quite a rowdy place, and I've seen usually disputes between members of the public and the taxi staff in the office. When people go and get a taxi, it can get quite rowdy, and so I think it's appropriate that people should be risk assessed on risk to employees just for their own employee safety, I think, and other taxi users. So I think, yeah, they're not the most salubrious places, not because of the taxi companies, because of irresponsible drinking, of which I never take part in.
Certainly.
Yeah, I think it's sensible, to be fair. I think, I mean, I'm not aware of any disturbances at taxi businesses on during the late nights in Salttree. So it doesn't really affect me personally as a councillor, but I have seen it in a previous life where, you know, but I think the judgment call from the operator to just consider it is an important one, because as Councillor Ferguson said, you know, they've got a duty to protect their own staff as well, really. So, yeah.
Thank you, Councillor Bywater. Yes.
Yeah, thank you. And obviously it's very much felt that it's not putting a financial burden onto the operator unless the operator feels it's necessary. But then as a safeguard, should events occur, incidents occur, we've got a bit more regulatory control to go back to these premises and say, well, what was your thought process? What's happened here? Are you fit and proper to have this office? So if we're all in agreement for that one, I'll just clarify the next point was the hours needed amended to 2,300 hours to 0,500 hours. And that was for the requirement to maintain a late night refreshment license. If any of these if any of these taxi premises decide to put hot food and drink for service at 2:00 in the morning, serving teas, coffees, burgers, whatever. It's just putting the onus that they obviously have to have the necessary requirements under other legislation. But that is the one that should read 2,300 to 0,500 hours. The nighttime economy hours are correct to 1,800 hours to 0,600 hours. So just to clarify that and check that you're all in agreement.
Yep.
Okay, thank you, Chair. Moving on to section 6.7. Due to the requirement of all dispatch staff requiring a basic DBS certificate, as referenced in the DFT statutory guidance, it will not be permitted for overseas call centres to be used by private hire operators. So we've become aware that some companies are allegedly using call centres based in India, where you ring up for a taxi and instead of being connected to someone in this district, you are being connected overseas. Your bookings then being sent back to the operator's pool of vehicles, and your bookings are being dispatched. Now, the Department for Transport guidance clearly states that operators should be required to evidence that they have had sight of a basic DBS check on all individuals listed on their register of booking and dispatch staff, and to ensure that basic DBS checks are conducted on any individuals added to this register, and that it is compatible with their policy on employing ex-offenders. So the DFT guidance is quite clear in that someone who has access to booking records has access to when a person's going to be in and out of their home. You book a taxi to go to the airport, you need a return journey from Heathrow Airport in 3 weeks' time. They know that property is potentially open and vulnerable for those 3 weeks, and the DFT guidance is that they should be DBS checking to make sure that people aren't maliciously accessing this information. Now, the response that we had to this is that the council permits certificates of good conduct for those it is seeking to license as drivers, and they are recommending that we also adopt a certificate of good conduct for any overseas staff. Now, it's our thoughts on the matter that the certificate of good conduct is to prove to someone who has permanently relocated to the UK for employment was in good standing in the country that they left from. It's not to do criminal background checks on people permanently abroad. And it's a circumnavigation of what the intention of doing a DBS check is. So we are of the opinion that the response to that is not reasonable, and the condition should be approved in its entirety.
Thank you. Is there any? Yes, Councillor Ferguson.
Sorry to keep talking. But on the list of things that I would never have considered, this is one of the things that, and so when I read this originally, I couldn't see what the objection would be to overseas call centres other than, you know, it reduces local employment. But you do make a very good point about access to data which could be used to facilitate crimes. DBSs aren't a perfect obstacle to that happening, but they're better than nothing. And so I think I would agree with these conditions as well, and that we should require DBS checks rather than certificates of good conduct, which I'd also never heard of before. So thank you.
Thank you. Thank you. Oh, Councillor Hale.
Yeah, it's just a query really. Regarding DBS checks, it says seeing sight of. I know recently they've become transferable, but the older ones were specific to who they were employed by or whoever did the DBS check. Is that going to be that they need one for that role, or that they can have a transferable one? Just as a question.
So it's just a basic DBS check that they would need rather than an enhanced one. So it wouldn't necessarily be role specific. And the guidance, I've only put a snippet of it within this report, but there is a bit further guidance on how that will be conducted. But the operators, it's clear in the guidance to us that the operators aren't required to keep copies of those DBSs. They just have to have had sight. How we regulate that is something that will evolve in time and really have to sort of work on, because it's not something that has previously been done.
Thank you.
Do we have a time limit how old the DBS can be?
So for a basic disclosure, you're normally looking at 3 years. For obviously the enhanced one. So for a driver, we check their DBS every 6 months. So, and they're normally on the update service, and we check it from that. So.
Thank you.
Yeah, just to come back in on that, the DBS guidance under the DFT statutory guidance doesn't provide a specific timescale for DBS checks on dispatch staff. It just says that they should have had a basic DBS check and added to a register to say that they were checked at the point of employment.
Okay, thank you.
Right, thank you, Chair. And coming on to the final point, which I'm sure you're all pleased to hear. Section 555.3, operators must have a list of current dispatchers and have sight of a basic DBS disclosure. Further information can be found in Appendix D. The response received to that was that it was unclear and required further clarification. And a separate condition in Appendix D sets out a wider group of employees that require a DBS check. And our thoughts on that are we can make alterations to the final wording to clarify that, and we would just mirror the wider group of employees into section 55.3, so then they both read identical. Thank you.
Thank you. No more questions? Thank you. So we're at the point now. Oh, Councillor.
Can I just make a comment and just thank William, because when I open up a 118-page report, I'm always thrilled, yeah. I couldn't imagine how we're going to get through this today. I think there's lots of criticism about public consultation, but actually the effort you've put into listening to all of the consultations, which there's been some really excellent responses, and moving your guidance to suit those responses, I think has been exceptional. And actually, it was a very interesting 118 pages, so thank you.
I think we can all agree with that as well. Thank you very much indeed. So the recommendations, I'll read them out. The committee has recommended...
Can we just take all of that last appendix, that you're all happy to approve everything that's been agreed in the last appendix, and then the chair will take you to the recommendation on page 13 of the report.
Thank you.
If you just want to read that out.
Yep. The committee has recommended to consider the draft policy documents and the responses received during the public consultation and approve the Hackney Carriage and Private Hire licensing policy to take effect from the 3rd of June 2024.
Are you all in agreement?
Are you all in agreement?
Yes. Any objections? Okay, thank you.
Thank you very much. Right, so now... So now we move on to number 4, Business and Planning Act 2020, pavement licences, pages 165 to 180. Thank you, Michelle.
Lovely, thanks for that, Chair. Okay, you'll be pleased to know my report's not quite as long, so we'll go through this one. I'm very delighted to say that the long-awaited pavement licence in legislation has now come through. It came into force 31st of March 2024, and what it's done is made the temporary arrangement of the pavement licensing regime under the Business and Planning Act a permanent fixture for us now in legislation. So I'm going to come on to the recommendations and then I'll go through the report. So following the report, what we're asking is that the fees are set today. So we're looking at a fee structure slightly different to what is available to be charged, and I'll go into more detail on that. But what we're asking for is that we have a fee set as fee A, and that's to a maximum of 5 tables and 20 chairs, and that's for a new licence, going to be £330, and a renewal. Oh, I'll get my words out in a minute. A new licence, £330, and a renewal, £240. For any pavement licences that want to have more than 5 tables and 20 chairs, we're looking at charging a fee there of £380 for new and £280 on a renewal. Just going forward in terms of the changes, if you like, that has been brought by this new legislation. So in terms of the fee structure, they would be for 2-year licence. So currently, as you remember, we've been doing this 12-month period, expiring obviously every September, but it'll now be for a 2-year period. What they've said is the maximum that we can charge for a new licence is £500 for 2 years and £350 for a renewal for 2 years. And as you'll see, I've made some changes there, and I'll go into the reasons why shortly. They've also looked at the duration of the consultation period and the determination periods, and they've both increased from 7 days to 14 days for each of them. 7 days wasn't really a significant time for us to do a consultation and determine it, so again, that's been listened to. As I said, the 2-year licence. Oh, the lights have gone off. Nobody's seeing me on YouTube waving. Okay, so the 2-year licence. The other significant difference is that the new guidance makes it very clear on the width of the space available. So it's gone to 2,000mm clear space to be provided between the furniture and the edge of the footway. However, there is a discretion that we can have a minimum width of 1,500mm if obviously that's an acceptable distance. But I think that's a really clear point that they've tidied that up and made it really clear. Within the report, we've got an Appendix B. They're the conditions that we attach to each of the licence. So we've got the mandatory conditions and the local conditions. There may be some national conditions that they're looking to bring out, but at the minute those have not been published, so obviously I can't provide those. But again, following approval of this, they'll all be on the website and they'll be very clear for the applicant to apply. The last significant change for us is that previously it used to be highways that was responsible for the enforcement and the removal of furniture from the highways that wasn't licensed under a pavement license. That's now obviously going to be part of us to enforce. So again, we've kind of inherited that, which is I think a positive step, because it means that, you know, we're able to look at areas that have not adhered to the licensing and can still liaise with obviously highways colleagues, but we can actually take that action. As I said, we've got the appendix there. I'm just going to move on to the fee structure. So looking at it, I and the team decided that, you know, instead of capping the fees at the blanket 500 and 350, because being honest, it's a little bit of a, we're not sure what enforcement action and how long that's going to take at this time. So what we've done is, as I said, broken it down into small businesses and then businesses that want over the 5 tables and the 20 chairs, just to, again, supporting that small business. I think it's good for the economy. I think it's good for our high streets that we do see this pavement culture, as long as it's regulated in the right way. So again, that's why we've looked at the fee structure to say, actually, let's support these businesses who just want a couple of tables out and a small number of chairs. So, as I say, happy to take any questions. And you know, my kind of recommendation obviously is that, you know, we approve these fees, and I'm happy to, again, as we do, we'll review them every 12 months, just going forward to see what we have. But happy with any questions.
Thank you, Michelle. Is there any questions for anybody?
Thank you. I'm delighted that the enforcement's coming to the council, because having had situations where we were waiting on highways to come and enforce it, it took nearly a year. So yes, congratulations on this and well done.
Thank you. Nobody else? Oh, thank you.
Just I welcome the streamlining of this pavement application, license application thing, because I think it's critical to many businesses who, you know, in difficult trading times, especially as the weather improves, lots of St Neots businesses would have gone out of business if not for the reformed pavement license conditions during COVID. And so having that kind of regime increased for longer or made permanent is, I think, really important for those businesses. So I'd support this fully. Thank you.
Thank you for that. Yes. Next page. Right, so we'll go to the recommendations. The Licensing and Protection Committee take note of the changes to temporary pavement licensing and proposed transitionary arrangements, and agree that the fee for the applications be charged at the set amount in the table below, which we had fee A up to maximum of 5 tables and or 20 chairs, and fee B over 5 tables and or 20 chairs. Are we all in agreement with that?
Which is set out in the table on
Yes,
page
on the other page, yes.
166
Yeah.
of your agenda
166.
pack. And then there's a further 2 recommendations: that the length of the licence be granted for 2 years, and that any appeal following refusal of an application be referred to the Licence and Protection Subcommittee. Are you all agreed? Yes. Thank you.
Thank you. Right. So now we move on to number 5, monitoring report on the delivery of food law enforcement and health and safety service plans, pages 181 to 190. To consider the monitoring report and delivery of service plans for food law enforcement and health and safety regulations for Q4. Thank you. Thank you, Kate.
That's it, perfect. Thank you. Thank you. So this is just a short report to update on the final quarter of last year regarding our food law enforcement and health and safety, following the service plans that were adopted in June 2023. So the main focus was the inspection programme, again with food hygiene. We were we were able to inspect 264 premises in the final quarter, which brought the total to 768 inspections being carried out throughout the year, which actually exceeded the level of activity predicted. In the Q4, there were 78 new business registrations, which was a bit less than previous quarters, but shows that there's just that continuing influx of food businesses as they stop and start and change hands, and each time that requires a new registration. We're still finding that quite a few businesses are registering a long time before they actually intend to open. which means that we kind of end up contacting them saying, can we come and inspect you? And they're saying, no, we're not ready yet. So it's a bit of turn and fro, and we've kind of fed this back to the Food Standards Agency just to provide more help and guidance to businesses about when they register. There's one red status on the appendix that you've got, and that again is to do with the alternative enforcement strategy. So we did start some work on this category E premises list last year, and we've actually got some additional resources been secured going into this year that's going through that list of premises, identifying whether they need inspecting or not, and if so, creating that record for the relevant officer, and if not, closing the business on our premises. So that work should all be completed this year and getting those businesses back into the inspection programme. As a reminder, they are the lowest risk businesses, so it might be a corner shop that's selling pre-packed food, or someone doing a small amount of home baking. In Q4, we had 9 compliance checks. So these are revisits to businesses where we found at an inspection there's some issues that need further attention. That overall for the year has meant the level of activity has been slightly exceeded. And I think that's generally because the businesses that we have been inspected haven't been inspected for 4 years. So sometimes we are finding the standards have dropped, but hopefully now they're back on the programme as usual. It will only ever be a 2-year gap between inspections. We also show in Appendix 1 that export certificates was slightly lower than previous years. There's nothing that we can do to influence this. It's literally what businesses come to us and they say to us, can we have a certificate for this? And we issue one, but it does mean that our income has been slightly lower than anticipated, and we've adjusted this for our forecasting in this year. We have, however, found that requests for rescores continue to be higher than anticipated in the final quarter. And again, I think this is a reflection of us visiting businesses where we haven't been there for a little while. They aren't getting the 5-star rating that they want, so then taking remedial action and then coming to us for a rescore, which is then hopefully getting them their 5 back. So we've continued to take part in the sampling activities that the UK Health Security Agency offers. In this quarter, the topics were around salad and salad components and ready-to-eat sliced and cut meat. So that was basically an officer goes out once a month, takes the samples, sends them off, and if anything comes back unsatisfactory, we will then either feed that back in. In this case, it was to a manufacturer rather than a business preparing the food in the district. The level of infectious disease control and the activity that we undertake in this has increased slightly. Since COVID, the UK Health Security Agency suspended all notifications to us for food and waterborne gastrointestinal pathogens, but they've now restarted this notification. So if somebody in the district gets, say, Salmonella or E. coli, we get a notification. We then have to go to them, undertake a questionnaire, which just goes back of sort of history, where they've been, what they've been eating, and we then feed this back to UKHSA to see if it links to an outbreak. So that's a new bit. Well, it's a bit of work we've done in the past that stopped, and we've just started doing that again. So we get a weekly email. So far, we've had, I think, this year about 10 cases come through to us. So it's not a massive amount, but it's just another thing that we are doing. In terms of health and safety, the majority of work in the last quarter was reactive. We had 16 accidents reported to us, of which we investigated 5 of those. The selection of accidents to be investigated was all based on the risk-based criteria that's set out by the HSE. We had 26 other service requests that we looked at. Most of these were licensing consultations where we focus on looking at public safety, and also there was a small amount of advice from businesses in the district. We also processed 11 skin piercing registrations during Q4. So yeah, I can take any questions on that activity if anyone's got any. Thank you.
Thank you, Kate. Is there any questions, please? Yes, Councillor Ferguson.
Just a comment to congratulate you for getting things back on track. For most of these meetings since I've been a councillor, we've been trying to explain away how we've been trying to catch up with the COVID restrictions, but it's back to business as usual. And I think this is an exemplary performance. And yeah, thank you for getting things back on track and getting so many greens for when I do my quarterly performance reports. Thank you.
Thank you very much.
Chairman, could I comment while you're flicking through your papers?
Yes, certainly.
Yeah, just really to echo that, I think the request for rescores has got to be a positive thing. I think really for the district, I think if people are coming back wanting fast 5-star ratings, that shows that the engagement we're doing. So yeah, good work, Kate. Well done.
Good point. Thank you. So the recommendation: the committee is asked to review progress and provide any comments considered appropriate on the delivery of the 2 service plans for Q4. Are you all in agreement?
Yeah.
Thank you. And then we'll move on to, which one's the next one? This one. This one. So we move on to number 6, service plan for food law enforcement, 2024-25, pages 191 to 212. To consider the draft service plan for food law enforcement. Thank you. Kate Penn.
Do you want to do your mic?
Oh, sorry.
That's all right. Yep. Is that Yep. Is that okay? Okay. So this is the service plan for food law enforcement for this year. We have a duty to outline how, as a local authority, we will fulfil our duty to deliver official food controls within the district. We have to show this to the Food Standards Agency, and it has to be laid down in a service plan in a prescribed format. So the plan that you've got in front of you follows that format. It details how we will undertake the official controls, which includes proactive food hygiene inspections and the provision of food hygiene ratings, as well as other key areas over the year. This mainly includes responding to complaints and service requests, sharing advice with businesses, and taking part in the UK Health Security Agency sampling campaigns. On the 1st of April 2024, there were 1,652 businesses registered in the district. This is a decrease of 88 businesses since last year, which is about what we'd expect. I think we're generally always within 100 or so of the previous year. Food businesses are inspected according to their risk rating category. The highest risk businesses, category A, have an inspection or a partial inspection every 6 months, and the lowest risk businesses are monitored using an alternative enforcement approach. The main priority of this year is going to be continuing this inspection programme, which is largely back on track as business as usual following the suspension and catch-up period after the global pandemic. And then we will continue with the other activities that I've mentioned earlier. So the service requests, giving advice to businesses, investigating infectious disease, and also following up any food alerts for action. That's one of the things I don't know if anyone's seen. The last couple of days there's been quite a large recall on pre-packed sandwiches. It's that sort of thing that comes through to us, and if it affects a business in the district, we'll go out and check that they've removed the food from sale. And if they have, that's all great. If not, then there's further steps we can take. So we'll continue this year with the quarterly monitoring reports that will come to committee, and I'm carrying forward the same indicators as the previous year, as I think that breakdown's been a bit more helpful than what we had previously. So I can take any questions or comments.
Thank you, Kate. Is there anybody would like to ask a question? Thank you. So the committee is asked to comment on, and if in agreement, approve the service plan for the food. Are we all in agreement?
Yeah.
Thank you. So we're going to, Yes, we go on to number 7, service plan for health and safety regulations. To consider the draft service for plan and health and safety regulations 2024 to 2025. Thank you, Kate, if you would.
Thank you. So this draft service plan is for our health and safety activity. The Health and Safety Executive is the national regulator, and they basically require us to fulfil our duty to make adequate arrangements for the enforcement of the relevant statutory provisions within its area. And our service plan is the way of setting out doing this. So we don't enforce health and safety in every business in the district. It's only certain ones, and this is set out in legislation. So the businesses that we do enforce the Health and Safety law at, we have a national local authority enforcement code and local authority circular that influences our priorities and what work that we can undertake, because it is quite prescribed. So the HSE approach is risk-based, and they have an incident selection criteria that we have to use to select certain incidents or accidents, diseases, dangerous occurrences, or complaints for investigation. And this means that we're using our resources effectively and focusing on the most high-risk incidents and what may affect the large numbers of members of the public or employees. And we use this, so if we get a statutory notification through, say, of an accident, that's when we would use this criteria to decide if it's something that we need to follow up. So say this is a premises that they've had a number of accidents in the last year, actually we need to investigate this, or if it's something that's perhaps quite unique, or if not, and all the information we've got, and it is a genuine accident that couldn't have been prevented, we may choose not to investigate that. So our main activity is going to be responding to service requests when they come in. But this year we also want to have more of a focus on some proactive intervention measures, which I think over the last couple of years, when the focus has been catching up on the food hygiene inspection programme, we haven't had as much time to take these proactive steps. So we're planning to focus this proactive work around safety with inflatable amusement devices, so the bouncy castles that you get in pub gardens, with fun fairs, that sort of thing. Electrical safety in hospitality settings. So we're still finding quite a lot of businesses are setting up outdoor areas where they've got electrics going out to provide lighting or heating at night time, so checking that they're safe. And also in kitchen areas, we're finding when businesses are struggling, they're doing a bit more work themselves, and perhaps it isn't always as safe as it could be. So just really providing advice and information on those areas. We're also going to be doing some work around cooling towers located in built-up areas. We only have a few in the district, but we're taking an approach on just reviewing the information we hold on those, checking which, we have a register, but checking which are still active, because people don't always tell us when they haven't got the tower anymore. And this is all to do with, should there be a Legionella incident, it's HSE asking us to check we've got the right information to hand. And the final area of proactive work that we've put on our service plan is to do with safety in marina settings. And this is largely based on local intelligence, where we've had a couple of incidents at marinas. So we want to target those just with advice and information, potentially some inspections, just to try and prevent any further accidents. And throughout the year, we'll continue to report quarterly to the committee, and generally, the level of inspections and service requests is expected, service requests will probably be fairly similar to previous years, but with the proactive work, we will have more interventions to report. So I'm happy to take any questions.
Thank you, Kate. Is there any questions? Yes, Councillor.
Yeah, I noticed it in the last policy document and this one. You talk about the 3 largest market towns in Huntingdonshire. Well, I think there's only one other, which is Ramsey. It'd be nice to include it.
I think the wording's taken from our corporate plan, but I can double check what's what's in there, definitely.
If that's the case, then it needs fixing, doesn't it? Because it's a good point.
Thank you for that. So, where am I from?
You need to go to the recommendation.
Yes, right at the front again.
Which I
Yep,
did.
thank you. So the committee is requested to comment on and, if in agreement, approve the service plan for health and safety regulations 2024-25, Appendix 1, in accordance with the Council's constitution. Number 2, request quarterly reporting figures on progress against the annual service plan for health and safety regulations 2024-2025. Are the recommendations okay? Thank you very much. Yep. On number 8, we've got suspensions and revocations of hackney carriages and private hire licences, pages 227 to 230. Would you speak on that, Michelle? Thank you.
Thank you, Chair. So this is the normal report that comes before you during every meeting. It's where myself or the Community Services Manager has taken delegated authority to refuse, suspend or revoke hackney carriage private hire licences. So during this period, you'll see from the table at 2.1, we've either suspended or revoked 13 vehicles and 4 drivers. As always, I'm not able during this meeting to go into sort of finite detail. What I will say is that if you look towards the bottom of that table, you will see that there's quite a few private hire vehicles that have been suspended. And I will say that there is some work going on within the team to look at an operator that we feel is not necessarily taking care of their vehicles in a safe and suitable way. So that's some ongoing work that we've got going on. In terms of 3.2, that was, as I've mentioned in previous meetings, we had a new driver that was refused. They was due to go so their initial, I think it's back in December now, was in court. That then wasn't available to be heard that day. They went to court, or they were scheduled to go to court in February 2024, and they decided to withdraw their appeal the day before it went to court. So, so obviously that driver has never received a licence. As I say, happy to take any questions, or if anybody wants to speak to me after about any specific matters, then that's absolutely fine.
Yes, Councillor Ferguson.
Thank you, Chair. Can I just ask the difference between vehicle defects, which is the long list at the bottom of the report, and then failed at approved garage due to dangerous defects? How do we pick up the vehicle defects? Is it through a garage, or how are those picked up?
Again, Councillor Ferguson, without going into too much detail, those vehicle defects was because we've looked at the history of that vehicle and we deem it not to be safe to be on the road. We gave them the option of getting their vehicle tested. They failed to do that, so at this time we've taken it off the road.
So that's helpful. I just think this provides justification for the decision we made earlier to enforce 6 monthly checks on cars. This is a massive list of potentially dangerous vehicles. So thank you for convincing us after the fact.
Thank you, Michelle. Is there any more questions? Thank you. Are we just noting that? So we've just noted that, and we'll move on now to number 9, licensing and protection subcommittees, page 231 to 232, to receive a summary of the meetings of the licensing and protection subcommittees that have taken place since the last meeting of the committee. They have their agenda item 9. Yes, Councillor Ferguson.
I might be missing. This seems to be a bit short because I sat on at least one committee for Gone Manchester, didn't we, Mr. Clark, as well? And there's been a few. So is this list
I'm afraid
comprehensive?
this is all I've got in front of me.
Maybe Democratic Services could help.
This is the Licensing and Protection Subcommittee, which is the taxi hearings. The Licensing Subcommittee is the premises hearings, which reports to the Licensing Committee, this is the Licensing and Protection Committee. So that will be reported to the next Licensing Committee. There have been several licensing subcommittees, as you're aware.
I apologise for my foolish error. Thank you.
That's fine. Thank you very much. As there is no further business, is there?
Now we added
Oh,
two
yes.
urgent items to the agenda for Ash to briefly update members on the St Neots Public Space Protection Order and the St Neots Civil Injunction.
Thank you.
Chair, I haven't read this. We have the notification. Should this be under part 2, or is this something we can discuss in public?
I don't believe it's confidential. I think it's just to notify members that they will be going out to consultation on the possible use of a public space protection order. It's not confidential, is it, Ash? No. Okay.
Thank you. Ash.
Yes, thank you. Again, sorry for this being really short notice, but this issue came up relatively recently, and it's felt that because of the important nature of the business, we couldn't really wait till the next committee in September, especially in relation to the behaviour, which I'll go into. So starting off with the Public Spaces Protection Order, this is a specific part of St Neots in the Amesbury area. There's a hotel and a hotel called the Nag's Head, which is being used as temporary accommodation for people who are facing homeless situations across multiple different council areas, not just Huntingdonshire. And because of its current use as for temporary accommodation, it's created an issue of transient population, which comes with its antisocial behaviour issues. Those antisocial behaviour issues are being managed well by the actual hotel itself in terms of within their premises, but of course a lot of the behaviour then spills out into the streets and the surrounding area, including the churchyard next door and the streets probably within about a mile radius of the location. We've had a lot of complaints from the residents in the area to Huntingdonshire District Council and to the police. The police have responded well to incidents of crime, and that's been well reported. But a lot of the behaviour either fall low or below the criminal threshold, and those issues have slipped through the net and gone under the radar in terms of enforcement. So we have scoped out the area with police. When I say we, I mean Huntingdonshire District Council's Community Protection Enforcement team. And we've looked at various options available to us for enforcement, and we feel as though a public spaces protection order is the best way to enforce the behaviours that are occurring, because we can put in quite robust conditions which cover those non-criminal behaviours, but still behaviours that have a significant impact on the residents and businesses in the area. The public spaces protection orders will go through they have to go through a period of consultation, and we will consult with members, and we will consult with all of the residents and businesses in that specific location. The public spaces protection order then needs to be approved by committee. But of course, a lot of the behaviours we're talking about, which I'll go into a bit more detail about in a second, will expect it to be worsening during the summer months. And we do not want to miss that opportunity of enforcement by waiting until September's committee to approve it. So as well as giving you a briefing on what is the current issue and the current plan, just wanted to make you aware that as well as coming to councillors for consultation, I will likely have to consult with the Democratic Services on bringing the committee together before you break for recess in August to look to approve this. So that being said, I'll go through, I've got a very rough draft at the moment of what we'd be looking at. So I'll quickly go through the general location and the behaviours that we'd be looking to put on the public spaces protection order, and then open up to any initial comments, although this isn't for consultation necessarily at the moment, just for initial questions really. So the area we're looking at is the parts of Berkeley Street, Buckley Road, Luke Street, Montague Street, Washbank Road, Pope Road, School Lane, St Mary Street, and all of the connecting footpaths. Also looking at the two churchyards in the immediate area, so that's the St Mary's churchyard and the Old Amesbury churchyard, which also includes the Millie Swing Memorial Park and going along the river up to St Neots Marina. The conditions that we're currently looking at, although these are subject to change after consultation, because we will of course be flexible depending on what the results of consultation are. But at the moment, what we're looking at would be conditions for no open vessels unless permission has been granted by a local authority for public events, that sort of thing. No personal use of narcotic substances unless they're shown to be used as part of a prescribed for a condition for prescribed purposes as prescribed by a medical professional. Encampments on public land unless given prior permission by a local authority, and also unless given permission by the landowner, which would have to be demonstrated in writing as proof. The reason for that condition is because the churchyard has had issues of residents who have been evicted from the hotel then camping in the churchyard because it's seen as a safe space for them to do so. But naturally that creates antisocial behaviour issues for people who are using that facility as intended. Public defecation and urination kind of goes without saying, that one really, but again, with the exception of unless there's a public toilet, of course they're allowed to use it to defecate and urinate there. And then finally, intimidating behaviour. So this will be intimidating behaviour which would fall below a criminal threshold, but not an exhaustive list, but examples would be aggressive shouting at any person, any offensive language, physical altercation, street harassment, which would be heckling or catcalling passers-by, and excessive noise, including music played from a device or instrument. So the Public Spaces Protection Order, if approved after consultation, will be enforced jointly by police and by Huntingdonshire District Council. The neighbourhood policing sergeant of St Neots has suggested that he's going to support this with police patrols and a proactive response, not just waiting for calls to service. And Huntingdonshire District Council will be responding to reports from residents in the area and enforcing as appropriate. So that is the current brief intention for the Public Spaces Protection Order. Happy to answer any questions on that.
Yes, thank you very much. It sounds horrendous. Can you... Yes, Councillor Ferguson.
How long would the PSPO be in place for?
Usually we put them open for 3 years, and then we tend to review them on a 3-yearly basis, similarly to what we did with the Public Spaces Protection Order for dog control back in September last year. And if it's deemed necessary to continue the PSPO, we will then renew it after a period of consultation.
Thank you. Yes, Councillor.
So if I could just comment on the application, I've been involved with this as casework. Well, it's Councillor Taylor and I went to visit many of the residents who are concerned about this. I think that the residents have been entirely reasonable in their objections. I think they understand the necessity to have temporary accommodation, but I think they just need it to be better managed. So I fully support this intervention, and I'm really glad to hear it. And I think a 3-year period is appropriate. It's unfortunate that we have to have temporary accommodation at all, but it's a necessary thing we have to do in order to alleviate homelessness, basically. So Huntingdonshire District Council places people in places like that to get them off the streets before we can house them properly. One of the issues, of course, is that it's a private operated building, and who can take in residents from any other councils as well, so we don't necessarily have any control who goes there. I think the residents' concerns are entirely legitimate, and I think they have been concerned about this kind of cyclical behaviour where they'll complain about things for a while and the behaviour improves and then it goes back again. And so I think putting this in place will hopefully address those concerns. I don't want to comment on all the points because it's going to go to consultation, but at first look it seems like a very comprehensive and sensible plan. So thank you very much for your action in doing this and for bringing it forward to this committee at short notice, because I think it will make a massive difference to the residents of Amesbury around that particular property. Thank you.
Thank you. Is there any other... Yes, Councillor Bywater.
Yeah, thank you very much for this. From what you've told me, I do support it. My only My only reservation, it may come out in a consultation. I mean, it's not my ward. I know St Neots, but not particularly well. Is there a danger that we push the problem somewhere else in the town?
Potentially, that is a potential issue with any kind of enforcement when it comes to antisocial behaviour and crime, is that people will naturally avoid where the enforcement is taking place. The nature of the antisocial behaviour that's occurring here, a lot of it's occurring because it's easy for the residents to behave that way, because a lot of it's on the doorstep of where they're currently staying. The further afield they go, the more difficult it is for them to behave in that way. And I think the main point is that the behaviour may continue elsewhere. It probably already does continue elsewhere by those same individuals, because it's again a transient population. But this is really to protect the residents who live in the immediate vicinity of that location, and we will act accordingly to any other location where similar such issues occur.
Yeah, my only plea is, it's this sort of issue is partnership working, which it sounds like you're doing, and if the police are doing proactive work, then this is what we need to do, isn't it? So yeah, thank you.
Thank you.
Excellent. So unless there's any other comments on the public space protection order, I'll briefly go over the civil injunction then. Excellent. So
thank you.
The civil injunction is a different enforcement power within the same legislation, the Antisocial Behaviour Police and Crime Act, and it doesn't require approval from members, but because of the nature of this particular civil injunction, we plan to go to consultation with members. So for a civil injunction, we apply for it through civil court, and we, similarly to a public spaces protection order, we put in place conditions. Often a civil injunction is used on a specific individual or a specific property, and you'd put conditions for that individual or property. However, in St Neots High Street, there's been over the past year issues of children predominantly climbing on top of the roofs of retailers and restaurants, causing antisocial behaviour, taking drugs, drinking alcohol, and abusing staff in restaurants and businesses. Businesses have reported significant damages to the rooftops, which has costed them thousands of pounds to repair. And they have been really supportive of any action at all that can help them. The other point to make is that this is occurring on private property, which is another reason not to go down the route of a public spaces protection order. And oftentimes, because of the age of the perpetrators, it's very difficult to respond because they're below the age that we would typically use for a lot of our enforcement actions. So what we're currently looking at doing is a civil injunction to persons yet known. So essentially it would cover a wide location, the St Neots High Street, and it would include anybody who we don't currently know but may act in a specific way as specified in the civil injunction. The reason why we're coming to members for consultation, as well as other partners, so we have to consult with Children and Young People Services, police, fire, all your typical partners. The reason we become to members is because of the nature of it covering a wide town centre location rather than a specific person or property. So this is just a quick briefing to the committee to let you know that when you receive our email for the consultation, this is the purpose for it. And just to say, we're not looking for approval, but support would be really appreciated by us and the businesses.
Thank you for that. Yes, Councillor Ferguson.
Is the consultation only for members, or is it for the wider public?
So consultation in the guidance is essentially for anybody who it is appropriate to. So because we're looking at children, we'll be definitely consulting with Children and Young People Services, consulting with the police because they'll be doing the predominant enforcement, and we'll be consulting with the victims. So the victims would encompass a range of the public, predominantly staff of the businesses. But there's no specific requirement to go broadly out to, for instance, all of the residents of St Neots, because of the nature of the guidance is that it's for those directly relevant to.
Thank you.
just to say thank you again for showing how powerful our enforcement can be when required. These are obviously things that we wish wouldn't happen, but I think that both of these actions are illustrations that we take our responsibility seriously. So thank you.
Thank you. Is there any other councillors wish to comment? So we just note that. Is that right? Yep, thank you. Well, I think that's the end of business. Thank you very much for your attendance and goodbye.